Rubin,
Yes.
you may proceed.
May it please the court, there is no assurance that there is diversity jurisdiction in this case. And until that's done, until that's established, which is going to require a remand and depositions and an evidentiary hearing in the district court, the other issues before the court today, which include inadequate disclosure of the magistrate of a close personal relationship with lead counsel at the trial, failure of the district court to withdraw the reference, errors in the unfair trade practices damage award and treble damages and other damages, and the failure to grant a new trial. We need not reach those yet today. Nonetheless, I'm going to touch on all those issues if I have time. But let me begin with the jurisdictional issue. On the face of the pleadings, IFG has failed to properly allege citizenship. Its original complaint was completely inadequate. Its second and third amended complaints did not even mention diversity. Its fourth amended complaint, post-trial, contained generic allegations about diversity and then attached a chart purporting to show diversity, which lists over a dozen individuals, sub-LLCs, and other entities. The magistrate, in fact, ruled on that fourth amended complaint within 5 days, issued a supplemental reasons for judgment and a judgment before the court had a chance to even answer or respond. Now, IFG's complaint flies in the face of this court's ruling in Smith versus Toyota, which I believe, Judge Higginson, you wrote, which held that a party asserting diversity must distinctly and affirmatively allege the citizenship of every party, including all LLCs. If IFG filed the same fourth amended complaint today, it would not pass muster under Federal Rule of Civil Procedure 7.1 as amended in December of last year. IFG's complaint was inadequate, it is inadequate, and sealing portions of it was improper. But even if you could get past the issue of sealing and unseal it, that's not sufficient. Because if you look at what supposedly supported it, it shows that discovery is needed. In fact, as this court and other courts have held, and as we have cited, discovery is usual and in fact normal when there are critical questions of diversity jurisdiction. Instead of allowing depositions of members of this stacked LLC, which included sub-LLCs and Cayman Island corporations, the rulings below relied upon an affidavit by one who was not a member of all of the entities and was not a controlling person of all the entities, limited the court to a deposition of one person who was not a member of all the entities and not a controlling person, permitted IFG to submit summary, fill-in-the-blank affidavits under seal that did not resolve the issue, especially when one examines the photocopy documents that were attached. When one looks at the sealed exhibits, for example, IFG filed photocopies of driver's licenses and passports of the members of the LLC sub-members. At least 3 of the individual licenses or passports had expired before this suit was filed in 2016. Look at sealed exhibits 40089 and following.
Rubin, there are definitely some irregularities on the diversity jurisdiction issue. I don't myself, looking at the sealed materials, see any reason to doubt that there actually was diversity, but it is an issue that you've briefed thoroughly, and we can look at the record. You have several other complex issues. Do you mind if I move you to another one?
Not at all, Your Honor. Glad to move on.
On the issue of magistrate jurisdiction.
Yes, sir.
Do you or don't you accept that the Carter factors that were applied is a legal framework we should use?
I agree that the Carter factors is a framework, but I also submit to you, Your Honor, that in fact the Carter factors were inappropriately applied here. Carter talks about voluntariness, but in Carter there was in fact a voluntary disclosure. Merely this was a pro se case in which the employee changed her mind midstream and wanted to get a new ruling. But there was no question that the disclosure from the magistrate at the front end was present. And in fact, the 5 factors under Carter, 3 are met here. So I do agree that those factors are appropriate, and they're met here.
So is there a standard review that the district court clearly erred? Factually, probably not, because there isn't much factual development except for the Mize affidavit.
I suggest to you that it is a legal question that is de novo, and let me tell you why. 28 U.S.C. 636, which is the statute, stresses the need for the court to protect the voluntariness of the party's consent. It's the court's obligation to do so.
But it is your burden to prove the Carter factors, correct?
It is, I'm not sure that the Carter factors require a burden of proof if, in fact, the disclosure at the front end was improper, because the Carter factors don't come into play unless you've already had a voluntary situation. I don't agree that those factors come into play if there's an involuntary situation, which it was here. The disclosure was partial. As the court knows from the record, the magistrate said, one of the lead counsel's daughters works for me, I'm going to screen her off. Fine, but it doesn't say anything else. It doesn't say that the lead counsel was a groomsman in her wedding, and doesn't say that shortly before the trial, she performed the wedding of yet another of the lead counsel's daughters. This is something that every trial attorney would want to know before giving up the right to an Article III judge.
The district court's actual ruling, though, faulted your client getting close to saying bad faith because it was after the fact and delayed.
And, Your Honor, my response to that is if the lapse of time can cure the lack of a disclosure, which is the court's obligation to give, then we discourage transparency and we discourage disclosure. We acted promptly. We acted promptly once we found out. We had no reason to doubt that the disclosure was complete. When we found out it was incomplete, that we acted promptly. In fact, sitting in the room when the disclosure was made was IFG's lead counsel and the magistrate, and both of them knew the situation, and both of them remained silent. And the one who was left holding the bag and unknown was us. Now, Your Honor, 28 U.S.C. 636 allows disclosure for extraordinary circumstances, and we submit here that it was an abuse of discretion not to find an extraordinary circumstance. Indeed, ABA Opinion 488 on judicial disclosure and disqualification says that not only close personal relationships are to be disclosed, but even friendships are to be disclosed.
Has that ABA opinion, to your knowledge, ever been applied in a 636 ruling?
No, it has not, to my knowledge, but it's been cited by other courts as appropriate. And indeed, it does.
What was the guiding 636 case other than Carter?
Your Honor, I'm not aware of any case where the disclosure was so inadequate. There is a case called Ceats, C-E-A-T-S, which was discussed in district court. It's a Federal Circuit case, in which case there was a mediator who did not give a disclosure, and the court held, well, it was improper for the mediator not to give it, but it wasn't extraordinary because he was only a mediator. He wasn't trying to resolve the case. I think if Ceats had involved a magistrate or a judge or an arbitrator, that would have been a different situation. But Ceats is the closest, Your Honor. It's not directly on point, but it's as close as we can find.
Because if we were to shift the analysis into the world of 455, the law is fairly forgiving. Would you agree?
I would agree, but 455 is about disqualification. This is not about disqualification after the fact. This is about disclosure at the front end. And as this court said in the 1980s, this is in the Moret case, again, cited in the district court's opinion, assuring the voluntariness of consent is a fundamental importance to the parties, because consenting to a trial before a magistrate waives the right to an Article III judge. It is of fundamental importance, and it's the court's obligation to do so. We believe that this is an extraordinary circumstance. We believe the trial court's reliance on Carter.
Jody's opinion would suggest, it seems to me, this is what he concluded. Well, your client was told there was a relationship of some degree of familiarity, close enough that the judge hired the lead counsel's daughter, and that maybe therefore gave you cause to investigate. But if you don't investigate further, you can't wait for a verdict and then, sworn affidavit that, well, these other factors suggest quite a closer degree of intimacy, maybe not enough under 455, but yes, under 636.
Your Honor, I would suggest that analysis shifts the burden. The burden is not on the party to investigate. The burden is on the court to disclose, the magistrate to disclose. And when the magistrate fails with that disclosure, there cannot be voluntary consent. Consent cannot be voluntary.
On this record, your case is more about partial disclosure, non-disclosure, than it is about any way we would know the degree of intimacy between Judge Kaye and Mr.
Correct. If the magistrate had said at the front end, I've got a law clerk, I'm a screener off. But he was a groomsman at my wedding, and I did a wedding for his daughter, his other daughter. Then client and counsel could make a knowledgeable decision whether they wanted to waive the right to an Article III judge. But they didn't have that opportunity. They didn't have that ability. IFG's lead counsel knew that. The magistrate knew that, but we didn't, and we didn't have the knowledge. And the burden under 636C2 is on the court to protect the voluntariness.
Would you agree you would have no argument if, in fact, you had found out or you already knew about that level of familiarity prior to the verdict?
Correct. Correct. This is not about what we knew, it's what we didn't know and who had the obligation to tell us. I want to move, if I could, to the unfair trade practice claim. Now, the unfair trade practice claim turns on unique issues of Louisiana civil law, and the treble damages cannot stand, assuming we get past jurisdiction and assuming we get past the magistrate's ability to hold and rule on the case. There are two reasons why the treble damages cannot stand. One is legal, and one is failure of burden of proof. There's no question that the key provision of this case, Section 8.9, is ambiguous. It states that IFG will, quote, arrange for and complete the initial dredging of the marine area alongside berth number 8. But it doesn't say who pays for the permit and who obtains the permit. It's ambiguous in that regard. And under Louisiana law, as recognized by this court in the Total case, an ambiguous contract has two reasonable interpretations. There is no Louisiana case, zero Louisiana cases holding that when there is an unfair trade practice claim, which is a penal statute narrowly construed, that when the interpretation of a contract turns upon that provision, you can have an unfair trade practice violation because unfair trade practices require egregious conduct after notice from the AG. But how can it be egregious if it's a reasonable interpretation? Now, I would agree, Your Honor, that you can have a breach of contract of an ambiguous contract. But I don't think you can convert a breach of contract to an unfair trade practice claim, as this court has said. It is not a substitute for a breach of contract.
I mean, this argument was made directly to Judge Kaye in March of 2020?
Well, it was yes, 2020, 2021.
Her response was, well, you know, I made findings that, looking beyond the contract, it was indefensible and it was in bad faith for your client to have had this notice of default when throughout you knew you had to do the dredging. And your own documents said that you had to do the dredging, get the permit to do it, so they could do it, right?
Well, but that prejudges it. That assumes it's not ambiguous. That assumes it's unambiguous, and that's not what it said. But let me turn to that issue, which is the second issue, which is the failure of proof in what she said. The only count in the original complaint that involved unfair trade practice was count 3. That was filed in January of 2016. The two big issues was the dredging issue and the issue of the default notice letter. Well, in February of 2016, shortly after the suit was filed, when an injunction hearing was pending, when the injunction rulings were yet to be made, the parties entered into a cooperative endeavor agreement. That's tab 15 of the record excerpts. And in that, they agreed to supersede the lease and that IFG would pay for the permit and that the port would obtain it. That resolved the dredging issue fully, and the magistrate gave no weight to that. The second issue was in April of 2016, which is when the letter came in, and I want to talk about that in just a minute. There is a meeting on the record. There's a minute entry. It's at the record at 17, in which IFG agrees it will take no further action on the default letter, will not do anything without court approval, and the court holds that therefore the injunction is moot. Now, what does the statute require? The narrow penal statute of the Unfair Trade Practice Act requires actions post-notice.
This is for the treble damages.
For the treble damages. It requires actions post-notice. There is no evidence of any actions post-notice that wasn't taken care of by the minute entry agreement, the stand-down agreement, and the cooperative endeavor agreement. Your Honor, I will stand on my brief.
Well, before you got 30 seconds left, when you say there's no evidence, I mean, again, she insisted that that same sword of Damocles was over their client well after the AG notice that incorporated the complaint and Claim 3 cross-incorporated all the earlier portions of the complaint. So she said the failure to give over the instability sloping evidence, all of that continued. It was a continuing plan.
Your Honor, that's what she said, but if you look at what happened, the continuing issues only involved count 3 and not the later amended complaints. So even if you could consider this without the letter in evidence, and the letter was not in evidence, and there's no Louisiana case holding that you could have a treble damages without the letter in evidence, when you work through all those issues, almost all of them were pre-suit or resolved by either the stand-down agreement or the cooperative endeavor agreement.
Thank you, Mr. Rubin. You've reserved time for rebuttal. You may proceed.
Thank you, Judge Graves, and may it please the court. Following a weeks-long trial that included more than 20, the testimony of more than 20 witnesses, hundreds of exhibits, the district court and Magistrate Judge Kaye made detailed findings of fact, including the determination that the port had engaged in unscrupulous and ultimately extortionate conduct in an effort to wring concessions from IFG and ultimately force it off the property. That conduct included misrepresentations about the stability of the area to be dredged, which, as Judge Kaye found, could have resulted in a catastrophic failure, including loss to the property and even loss of life. The port here doesn't challenge any of those determinations. Instead, it's raised a bevy of additional arguments that underscores the weakness of their case. With the court's permission, I'd like to address the arguments that were raised earlier today. On jurisdiction, Judge Kaye carefully looked at jurisdiction. It found that there was complete jurisdiction among the parties.
Fair to say pleadings were deficient, but it was cured?
Exactly, Your Honor. And the port admitted in its reply brief, which is true, that pleadings can be amended after in this situation. That's a
There were a lot
note.
of sealing orders, many of them no reasons. In fact, only one had reasons, which was pretty general, just the privacy of ownership. Those sealing orders look hard to defend.
Your Honor, those would be subject to an abusive discretion standard. I mean, Judge Kaye, who had lived with this case, I think appropriately determined that sealing was appropriate. The port ultimately had access to all the documents. I would refer you to the chart at 39964 of the record, the membership chart. There was affidavits by Mr. Ahmad and others. And ultimately, the judge concluded that there was no basis for discovery in this case. That's at record 4663. I don't think there's any basis to find an abusive discretion in that determination. The Smith case is completely distinguishable, and that they admitted that there was no diversity among the parties. Here, the evidence shows that there was complete diversity, and there was simply no basis to go any further in digging into that in a fishing expedition. Now, with respect to the referral, an attempt to vacate Magistrate Judge Kaye's referral following years of proceedings in this case, a lengthy trial, 64-page decision. What they came up with was a 3-page affidavit, and that's at 22907 of the record, and I would urge this court to review that affidavit. Ultimately, what that affidavit says is that they had determined, through means unknown, that there was a, quote, long-standing personal relationship among Judge Kaye and a person in Judge Kaye's husband's bridal party, and that Judge Kaye had performed a wedding for the daughter. Now, a long-standing personal relationship, as Your Honors I'm sure well know, is not in itself inappropriate. Relationships among judges and counsel are not discouraged, and that's particularly true.
Failure to disclose the same inappropriate.
Well, I don't think it was here, Your Honor. I mean, of course, she disclosed that one of her law clerks was the daughter of Mr. Monk, counsel for IFG. I think each judge has to determine what relationships are so close that they would warrant disclosure, recusal. She had a recusal list of individuals that she was so close to.
Now you're jumping to recusal, and I don't think that the two bodies of law don't necessarily inform one another, correct? Because the port had a constitutional right to get an Article III judge.
It did, Your Honor, and I think
The only way Magistrate Kaye even has constitutional jurisdiction is because consent is voluntarily given. And the argument here is it can't be voluntary if a judge selectively discloses one thing I employ lead counsel's daughter, but I'll screen her out. And then Mr. Monk and the judge both don't say, and just before lawsuit here, I officiated the wedding, and he was a groomsman in mine.
So I think a couple things, Your Honor. First, I don't think the quote-unquote longstanding personal relationship that's described in the most general terms in the affidavit in itself is sufficient to vitiate the informed consent. I think that's it most cumulative. Sorry, Your Honor.
Alleged social relationship, and you draw the comparison, so did the district judge, to just the ones anyone in Lake Charles would have. Where is there any way we can meaningfully review those factual characterizations? When the only thing we've got is the Mize affidavit describing quite an intimate family relationship. Where would you point to in the record to support your characterization of this as just equivalent to a judge with any lawyer in Lake Charles?
So, Your Honor, I don't, first of all, the affidavit doesn't say it's an intimate relationship. It says it's a long-standing personal relationship.
Each in the other's weddings, officiating weddings and in the wedding party.
So
Is that anything but an intimate family friend?
I think it certainly could have been a friend to her husband. We don't know if it was a friend to the judge. I think if someone is going to come forward after a trial, they have a burden to lay this out in more detail.
On that point, I have difficulty too with your position and the district court's position that this is after the trial, and you said in your brief, untimely. If the only sworn statement we have in the record is it's not untimely, the minute he discovered it, he disclosed it. How can you assert in your brief it was untimely if you opposed deposition of Mr. Monk and the sworn statement of Mize is that the minute they found this out, they disclosed it? Why is that?
So I don't think that's what the affidavit says. The affidavit is written very general and I think coy terms, Your Honor. But I think more fundamentally, under the Carter factors, voluntariness is just one of many factors. It's not the only factor. And there's no basis to set aside a referral that I'm aware of simply on a determination that more information, should have been disclosed if that's what Your Honors believe. And again, there's a wide range of friendships, and we don't know that the circumstances here at all triggered even a recusal situation. ABA 488, which my friend referred to, itself says that most friendships don't require recusal. It only sort of carves out special relationships like romantic relationships or otherwise.
Well, I guess I'm less concerned about the nature of the relationships and the friendships than I am about the failure to disclose it. Because what is concerning for me is that a disclosure was made at all. And so when you make a disclosure, if I'm sitting on the other side of the counsel table, I now assume that's all that needs to be disclosed with regard to the relationship between the judge and plaintiff's counsel. And I've hired lots of law clerks without ever knowing who their dad is. But if I came to know that the father of a clerk was about to have a 3-week trial before me, I'd feel compelled to disclose it and do what she did and say I'm going to wall off the clerk. But then there are these other two things, which there's the wedding that she officiated, and then there's the one where plaintiff's attorney was a groomsman in her wedding. So when you make one disclosure, how is it that you determine you don't need to make the other two disclosures, assuming they're true?
Right. So ultimately,
without any concern about how intimate the relationships. I've officiated lots of weddings where I didn't have any intimate relationship with anybody. They knew me, I knew them, and I did the wedding. So, but when you start making disclosures, then the assumption from the other party is then you disclose everything you need to disclose. You agree with me that if you were on the other side, you would like to know whether or not the judge just officiated a few months before the trial, officiated the wedding of the daughter of plaintiff's counsel. You'd like to know that, wouldn't you?
So, Your Honor, I think judges officiate lots of weddings. I think the assumption there is that there was...
That's not my question. Wouldn't you like to know that as the counsel on the opposite side from the lawyer who just had the judge officiate at his daughter's wedding?
What I could say, Your Honor, I haven't been in that situation before. What I could say is I think she disclosed what was most relevant, that the counsel's own daughter was clerking for her at the time. But I think more fundamentally, the legal point for this court is voluntariness is just one of several factors under the Carter analysis that my friend acknowledged applies here. Even if you think that more should have been disclosed in retrospect, it's a serious thing to go ahead and vacate a trial that the parties in the court have spent years adjudicating, resulting in a judgment. You would look also to the possibility of bias, which Judge Doty looked to and found that there was no bias here. Judge Kaye had made rulings on both sides throughout this case. You would look at how long it was after the initial referral was made that this issue came to light, and here there was years. You would look at the interests of justice, and here we're talking about wiping the slate clean, going back, and there have been years of proceedings.
Could be flipped around. Interests of justice, the public absolutely wants to be sure that judges don't have conflicts of interest. And in terms of rulings, if we look at her rulings, of course, a huge issue in this case is she granted treble damages, $124 million plus, virtually unprecedented in Louisiana law. So it's sort of hard for me to think the other factors are all in your favor. Certainly, additionally, you keep saying it's untimely, it came up too late. But the only sworn statement we have in this record is they brought it up the minute they found it.
Again, I would urge you to read the affidavit, Your Honor, but on the treble damages, I mean, I'd be happy to talk about that. But Judge Kaye made detailed findings about why the port's conduct here warranted treble damages under the Louisiana statute. And I don't think there's any basis for determining bias on that. Those were well-founded by the record. And that conduct superseded the AG's notice as well. I mean, not only with respect to the continuing sword of eviction that the...
She listed 9 violations under Lupta. And I'm sure we're not finished with this magistrate, but if we jump to that, when you say it's so obvious, you helpfully cited that McIntyre article. Do you recall that, the 2017 article about treble damages?
Yes.
And only one case since 1972 had affirmed treble damages in Louisiana. Only one since 1972.
Well,
so when you say this fits so easily, what Louisiana case has affirmed treble damages?
I don't have a specific case, Your Honor. I don't know that we've looked. I don't think there, I mean, there's no question that the statute allows for treble damages based on this finding. And here,
as the law suggests in that article, you've got to be able to trace the conduct, the misconduct that the Attorney General has given notice to as having recurred later. So if I were to ask you to do that as to one of her 9 violations, which one, specific one, recurred after the AG's notice?
so I can give you 3, Your Honor. I mean, first, they continued to mislead IFG about slope stability, which went to, the threat of loss of life and property. That's at record 21-734 to 35.
I'm sorry, 21?
21-734, 35. As Judge Kaye found, continued to hang the sword of eviction over IFG's head. That was at 21-732. And the port forced IFG to pay $510,000 in dredge spoil disposal costs, even that was plainly not required by the contract. That's at 21-733. And all of this is the same continuing course of extortionate conduct that began prior to the notice. And we have many cases showing that when you have this continuing course of conduct that begins before the notice and continues afterwards, that the Louisiana Unfair Trade Practices Act is warranted. And I could give you cites to those cases, but
Louisiana state cases?
yes, Your Honor, I'll give you a few citations to that.
The most recent major decision is Fat Cats, correct?
That is one of them, Your Honor. I would point you to McFadden versus Import 1, 56 South 3rd, 1212, Hadassah, 216 Westlaw, 156264. That's a Western
These are
District.
in your brief.
I believe they are, Your Honor. There's the Fat Cats case as well that acknowledges continuing course of conduct. But the reason why damage...
Fat Cats reverses the treble damages in that case.
Because the evidence was lacking of the continuation after the AG notice, which is present here.
Well, but again, the courts seem to be very strictly trying to trace the conduct that occurred, that then they're on notice, don't repeat that. So when Judge Kaye says, well, the same sort of fear of eviction continued, that to me is a much more expansive general level. Would you have a case that allows that? It's bordering on, will they continue to litigate their contract interpretation? And ultimately it was shown that that's not a viable interpretation. but is that egregious bad faith conduct to not settle?
So with respect to the contract interpretation, Your Honor, I mean, this court in the Chemical Distributors versus Exxon case allowed an issue of contract ambiguity to go to the jury, so I think that's a viable claim. But the more fundamental point here is this conduct went far beyond taking a different interpretation of a provision. They took that, and then they made false statements in a default notice. They told IFG's lender that they had to threaten an eviction.
Notice, to be clear, preceded the AG notice.
It did, but it's well, it's part of it's the beginning of a course of conduct.
It's part of, that's what the judge said. But what's the conduct, the specific prohibited conduct that continued?
So
Litigating pattern.
well, I can repeat the three that I gave you before. I think the most basic one is continuing to mislead about slope stability issues. That there had been studies made on that when they were relying solely on the whiteboard calculation of Mr. Brinken, and that continued afterwards. And that was...
I agree, and we'll hear what opposing counsel says, but that was a non-disclosure, correct? They didn't disclose that their internal documents suggested they knew the slope was unstable.
Well, they repeatedly made statements, false statements, including in the default notice, that there were no... But again, we're talking about...
When we say that, because the default notice precedes the AG notice.
Right, but it's clear in the citation I gave you is that they continue to represent the absence of slope stability issues.
Their failure to withdraw the default notice is what is actionable? Is that what you're arguing?
No, Your Honor. We're arguing that there was a continuing course of extortionate conduct that began before...
Specifically with regard to the default notice, what was the action as on that particular issue?
Well, this was prior to the AG notice. The default notice, one, misrepresented IFG's obligations under the lease agreement to say that we had this permanent obligation. Two, falsely stated that there were no geotechnical issues with the dredging and claimed that we should have begun the dredging. And then they took that default notice, they sent it to our lender, they threatened eviction, and this was all a course of conduct designed to hang the threat of eviction, to wring concessions out of this.
And
this
all predated the AG notice? Am I right or wrong?
Part of it did, Your Honor, but not all of it. After the AG's notice, it continued. It continued by continuing to misrepresent the slope stability concerns and the fact that there had been no geotechnical study, by continuing to hang the threat of eviction over us as a means of extorting concessions out of us, by forcing us to pay $510,000 in dredge disposal costs that the lease agreement itself clearly required the port to expend in order to force us to go ahead with the dredging under those situations. So it was all one course of conduct that continued after the AG's notice. And we could acknowledge that this isn't it's not the typical case. You should have to show a lot of evidence to get treble damages. But there is tons of evidence in this case and tons of factual findings that aren't challenged. They have not challenged any of the factual findings pertinent to this from Judge K's 64-page decision. So if there was ever a case in which treble damages were warranted, it's this case. And the fact that they're warranted comes from a Louisiana statute that this court obviously would give effect to in this diversity action. What they're doing is grasping at straws, trying to say that the conduct didn't continue or that somehow they weren't on notice, that they had engaged this inappropriate and extortionate conduct, which Judge K again found. She found that it was outright extortion. This isn't common commercial practice among parties, Your Honors. I mean, and this record here couldn't be more clear that that was the inappropriate conduct that they engaged in. And again, if you want to look at one thing from the decision, I'd urge you to read page 2717 of the decision, where she says that she talks about how the statements about slope stability were not only false, but dangerous. And here I'm quoting, dredging activity that undermines the stability of adjacent facilities could lead to catastrophic failure, with which in turn could lead to loss of property or, more importantly, loss of life, or both. Yet the port continuing to make these misrepresentations, knowingly saying that there were no geotechnical concerns, even though it knew there were because of the permit that it had previously gotten because of its own studies, and yet it misrepresented that and tried to force IFG to undertake this dredging activity anyway, which put everybody at great risk.
Back on 636.
Yes.
We went off to the treble damages because
Sorry, Your Honor.
you were pointing out that district court has
Yes.
said the rulings looked fair to him. But back on 636, you're not making the argument to us that this motion to vacate the denial of the referral had to have been brought back to her directly under 455 or to her directly under 636.
No, but it is.
You're saying it was properly brought, properly analyzed by the district court using the Carter framework.
Yes, we are, but I do think it's noteworthy that they didn't go to Judge Kaye and say, you should vacate your referral. They went to Judge Doty and said, vacate the referral. And I think,
If it's properly framed and analyzed as to Carter before the district court, the issue is, did he abuse his discretion in not seeing an extraordinary?
yes, that's exactly right.
You look at the factors and it's developed as it is now.
That's exactly right. And I think this court could find that it had been better in the grand scheme of things for Judge Kaye to disclose the prior relationship as well in a more complete fashion. But yet, nevertheless, looking at the Carter factors, there was no abuse of discretion in finding that there were no extraordinary circumstances that warrant vacating the referral, wiping the slate clean, and going back and having to go through years more of litigation before a different magistrate judge, in which there's no reason to find, based on Judge Kaye's extremely careful and detailed findings, which they don't challenge before this court, that the port had engaged in conduct that warranted treble damages under Louisiana law.
Thank you, Counsel.
Thank you, Your Honors.
Bottom.
I'd like to begin by addressing Judge Higginson's last question, which is how come it wasn't filed with Judge Kaye? In fact, it was filed with the district court, and Judge Hicks sent it to Judge Doty. We simply filed the motion to vacate. Counsel said that there was continuing conduct, but he didn't talk about something that was very important that I mentioned earlier, which is the stand-down agreement. In the record at page 71, there's a minute entry, in which case, and I'm going to read it to you. The port agrees that it will take no action on the outstanding notice of default, no action, related to the dredging issue without leave of court, including the issuance of a second notice of default. In light of this agreement, the motion to expedite the hearing and a preliminary injunction is moot. The question of forcing somebody because the default notice was not withdrawn was a dead issue in April of 2016. Next, counsel talked about continuing conduct, and you asked about the AG's letter, which was not in evidence. You noticed, I'm
I
sorry.
remember Judge Kaye's response to that was, you didn't say you'd enforce it, but you still didn't withdraw it.
There is no case that holds that litigation conduct is sufficient for treble damages. You don't have to, and there's another case, you don't have to fall on your sword and withdraw your defenses if you feel you have
But
to.
in FATCATS, the court did distinguish, but it seemed to not disapprove of the Western District of Louisiana litigation about treble damages based on the failure to repay. And it used that broad language of, if an overall conduct, the failure to repay could have been further on. You probably read that.
I did. That's the Mims case that they were talking about, Your Honor.
Why wouldn't that map onto this?
Because in the Mims case, that was part of a continuing area of conduct. There are two things that stopped. Number one is the notice of default stopped any action to evict. You couldn't have compelled anything after that without going to court. You're not entitled to say you must withdraw your notice of default when in fact you've said I'm not doing anything without going to court. And in fact, we went to court after that.
What about the record citation to the fact that you continued well after the AG notice to withhold internal documents that prove the falsity of, oh, you can get your permit, there's no stability problem?
And the question then is, what did the AG's notice prevent that? No, the AG's notice is not in evidence. The only thing that was, but even if that's the case, even if you could take notice of it outside the trial, which there's no court that says you can do so.
But the AG notice incorporated the complaint and reincorporated virtually.
Count 3 was narrow. count 3 did not incorporate it, and they amended several times to expand it. But count 3 primarily involved.
Reference to the instability,
No, not in count 3. Look at what count 3 looks at. It looks at the dredging issue primarily and other things. But the other thing I will concede is that the $510,000 arose afterwards, okay, about the spoil issue. But again, look at whether it was mentioned in count 3, because if the agency notice acts as a cease and desist, if you don't know what you're ceasing and desisting from, you can't be claimed that we violated something when you don't know what you're supposed to have ceased and desist for, and they never proved it.
little time left. What about his response to the magistrate referral issues? You haven't talked about that.
The magistrate referral issues, Your Honor, I think I've answered that. We filed it with the court, and it was
I
that.
understand that. Do you have any other responses you'd make to?
Yes, I do, Your Honor. Every lawyer and client deserves a chance to have an Article III judge. And when they're asked to waive that right, they should have knowledge of the situation, not whether the judge is prejudiced, not whether the judge is biased, actually, but whether or not counsel and their parties perceive that there is that possibility, so that they can make a knowledgeable decision whether to take the risk and make that decision. In this case, the magistrate and IFG's counsel took the risk that we wouldn't find out, and took the risk that that wasn't important enough to disclose. But that's not where the burden of proof should lie. The burden of proof on voluntariness, as 636 says, is it's the court's action to protect the voluntariness. And when the court fails to disclose, it is not protecting the voluntariness of the right. In that case, Your Honor, no matter when the issue is raised, the court must protect that. And I urge the court, I'm sorry.
Well, I was just going to say, part of my difficulty here is I was looking for even that moment of consent. And in the moment where apparently Judge Kaye said, I'm employing Mr. Monk's daughter, I don't find any transcript or any minute entry.
There is none.
So where do we even know what Mr. Monk and Judge Kaye said at all, even as to the daughter that was working in her chambers?
It's not in the record, but all the parties agree that that's what happened, and there's been no denial of that. No denial by IFG that that's in fact what happened, that that was a sole disclosure, and that...
No one's suggesting in that conversation that's not recorded anywhere that maybe she might have actually said some other point.
There's been no suggestion of that, whatever, and there's been no suggestion by IFG that any of the materials in Mr. Mize' affidavit was incorrect or inaccurate. Thank you, Your Honor.
Thank you, Mr. Rubin. The court will take this matter under advisement.